All right, good afternoon, Mr. Smith. Can you see and hear me?
Yes, sir, I can.
All right, Mr. Weiner is in the hearing as well. Let him get his audio and video, and then we'll proceed.
Hey, Judge. Sorry, my coat's in the back of my truck. I'm in between Corsicana and Waxahachie.
Okay. All right, this is cause number CR 19-207, State of Texas versus Ryan Emanuel Smith for docket call. Mr. Smith is appearing via Zoom from the Henderson County Justice Center. Go ahead, Mr. Weiner.
Yes, Your Honor. If you'll recall, at the last setting, we asked for some additional time since Mr. Smith was being housed in Henderson County at Henderson County's cost, so that we could try and resolve the case. I believe we've reached a resolution in this case in Van Zandt County. There's a little tweaking that needs to happen in Henderson County. There's some additional information that was provided to the state. They are waiting on a supplemental report, and it's my understanding that when they receive that, they will run their case CC with the agreement that we have in Canton. And so it's a report that's coming from the sheriff's office, so it shouldn't take very long at all. If it's okay with the court, I'd like to set this for a plea 30 or 45 days out, and that should give us plenty of time to have everything buttoned up.
Mr. Hartwell?
Your Honor, state's in agreement with setting it out for a plea.
You think we could do it by September 24th? About 30 days, Mr. Weiner?
Let me see. I believe so. There is a chance that I will be in jury trial on the 392nd that week. But if so, I can just file a motion for continuance.
What about October 1st?
October 1st would be great, Judge.
All right, let's do that. Court sets Mr. Smith for plea October 1st at 1:30. And Mr. Weiner, will we need to bring Mr. Smith to the Van Zandt County Justice Center for you to go over the plea papers with him, or will you do that in Henderson?
Whatever's best for the court. I'd prefer him to be in Van Zandt County for the plea, just being in person. But if the court would rather me, see him in Henderson County, I could do that as well.
No, if we need to do the plea, I just need to know when we need to bench warrant him, or if we need to bench warrant him. So it sounds like we need to just have him brought over for October 1st. Correct?
That sounds right, Judge.
Okay. All right.
Yes, sir.
We will make that happen, and we'll see y'all on October 1st.
Thank you very much. That's all I have. May I be excused?
Yes, thank you, Mr. Weiner. Thank you, Mr. Smith.
Yeah, thank
Yes,
you.
sir.
Appreciate you letting me clear via Zoom. Thank you.
Absolutely.
Thank you.
You're welcome, sir. Let's see. I think that's all we have from the Henderson County Jail. So I think the only other one is Coffin County Jail. So I'll go ahead and I'll turn the video off for you, Mr. Smith. Have a good day, sir.
You too. Thank you.
Mhm. All right,
Yes,
we're
you're
ready
ready.
we're ready whenever you are, Miss Abraham.
Okay. Just a moment.
And Miss Abraham, there is someone in the waiting room named Cisco. I don't know if that's related to Kaufman County or not.
That may be, they were supposed to appear at 2.
So if Mr. Schmidt is ready in a moment on whenever he's ready for Timothy Lane Simpson, we can try to bring them in and get them gone. Get
Okay.
caught.
Your Honor.
Yes, ma'am.
And Mr. Schmidt is ready to do Kaufman County.
Okay, let me bring them in.
Yes, sir.
All right, Mr. Simpson, can you see and hear me okay?
Yes, sir.
Okay. This is, and can you also see your attorney, Mr. Schmidt?
Yes, sir.
Excellent. This is cause numbers CR 24-32, 33, and 34. State of Texas versus Timothy Lane Simpson, set for docket call. Mr. Schmidt, go ahead.
Judge, I would ask the court for a final docket call. And I would ask that Mr. Simpson be brought to Van Zandt County for me to meet with him in person prior, 24 hours prior to that final docket call.
All right, is Mr. Simpson being held in Kaufman on Van Zandt County charges? Are we aware, or will this require? a bench warrant?
He has been held on a TDC sentence that he's serving in Kaufman County. We have a hold, so we would have to bench warrant him here.
All right, court will set Mr. Simpson then for a final docket call on October 15th.
Hey, Judge, just a quick thing. With him being on a TDC, we have to bring him over there. We're not allowed to just let him come to y'all and y'all pick him up.
I'm sorry, say that again.
With him being on a TDC hold with us, because he's serving his TDC time here, we're not allowed to just let him go with y'all. We have to actually take him over there.
So if I send a bench warrant, will the bench warrant authorize you to take him and bring him over? Or you're saying
Yes, but it's the day of. Like, we have to take him to the courthouse and bring him right back. Like, he can't stay over there.
I see. So you're saying he has to remain in your custody?
Yes, sir.
And so he's not being held by Kaufman County. He's actually serving a TDC sentence in your facility.
Yes. He's serving a 4-year here.
Okay. All right. Well, thank you for that information. We'll get that figured out.
Yes, sir. Thank you.
All right. All right, Mr. Simpson, we'll see you on October 15th and I'll work out all the logistics. All right, Mr. Schmidt, who else you ready on?
Crystal Pitts.
This is cause number CR 18-495, State of Texas versus Crystal Irene Pitts for a plea. Are we pleading today, Mr. Schmidt?
Our judge, we're pleading to the state's motion, pleading true, waiving the formal reading of the state's motion as well.
All right. And what's the agreement?
Judge, the plea agreement in this case is that Ms. Pitts intends to plead true to the state's motion. State recommends that her guilt be adjudicated, her probation be revoked, and that she be sentenced to 8 months confinement in the state jail facility in order to pay the balance of her financial obligations. And she has 41 days jail credit time towards that sentence.
All right. Thank you, sir. All right, Ms. Pitts, if you will, please raise your right hand. I'm going to place you under oath. Ms. Pitts, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Thank you. You can lower your hand. All right, Ms. Pitts, you appeared before the court on March 12th of 2019. And on that date, you pled guilty to the state jail felony offense of credit card or debit card abuse. The court found that there was enough evidence to convict you, but the court did not. The court followed a plea agreement in which the court deferred a finding of guilt and placed you on 4 years of community supervision. Court also assessed a $1,500 fine. It was during that period of community supervision that the state filed in August 17th of 2020, its motion to adjudicate and revoke. And in there, it alleged what appears to be 9 separate counts or allegations of violations. Have you had enough time to review that with your attorney, Mr. Schmidt?
Yes.
Are you pleased with Mr. Schmidt as your attorney and the work he's done?
Yes, sir.
And do you understand everything that you read and signed that's part of your plea agreement today?
Yes, sir.
Do you have any questions before we go further?
No, sir.
Mr. Schmidt, do you believe Ms. Pitts to be competent to enter into this agreement?
I do.
All right. Understanding the motion, Ms. Pitts, I would ask you at this time How do you plead to counts 1 through 9 in that motion? Are those counts true or not true?
Sure.
And you're telling me that those things are true because in fact they are true. You're not saying that for any other reason, correct?
No, sir.
All right, the court will accept the defendant's plea of true to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection.
All right, that is admitted into evidence, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then, based on Ms. Pitt's plea of true to each count as alleged, court finds each count to be true, and on that basis finds that Ms. Pitts has violated the terms and conditions of her community supervision. The court will follow the plea agreement between the defendant and the state. The court hereby adjudicates her guilt, convicts her of credit card or debit card abuse. The court hereby revokes her community supervision, assesses her punishment at 8 months confinement in state jail. The court orders her to pay the balance of her financial obligations, and the court awards her 41 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Pitts, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Two things. The first thing is when you do get out of state jail, if you have any fines, restitution, court costs still owing, those will not go away until you discharge them. So that means when you get out of state jail, it doesn't mean that it's over and it's done and those are gone. It means that you need to come up and make arrangements at the courthouse with the district clerk's office to try to pay those. Otherwise, a warrant may issue for your arrest and you could be rearrested and held for your non-payment for a period of time. Do you understand that?
Yes, sir.
So to avoid that, when you get out of jail, you just need to come up and try to make a payment arrangement, and the county will work with you to keep you out of jail as long as you make a good faith effort, okay?
Thank you.
Secondly, step over to the deputy and let him fingerprint you, and they'll give you more information over there. Who's next?
It's Alicia Joiner.
All right, this is cause number CR 20-127, State of Texas versus Alicia Renee Joiner. I show that Ms. Joiner's motion to adjudicate, the state has filed a motion to withdraw and continue her on community supervision with an agreement with Ms. Joiner that she will amend her conditions of community supervision and that she will attend the substance abuse felony punishment facility. Is that correct, Mr. Schmidt?
That's correct, Judge.
All right, Ms. Joiner, if you'll raise your right hand, I'm going to place you under oath. Ms. Joiner, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. All right, Ms. Joiner, you've heard me state the agreement between you and the state that you will remain on community supervision, but as a condition, you're going to have to go to safety.
Yes, sir.
Is that your agreement?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead or to make that agreement today?
No, sir.
Are you pleased with Mr. Schmidt and the work he's done for you as your attorney?
Yes, sir.
And do you have any questions before we go further?
No.
Okay. All right, then the court will grant the state's motion to withdraw, and the court does approve the amendment to the conditions of community supervision for the placement of Alicia Renee Joiner at the Safe P facility. Court will sign that. So Ms. Joiner, there's really no sense in saying good luck because it's not about luck when you're going to a place like Safe P. It's about work. It's about effort. It's about being intentional. So go down there and be intentional about your work and put in a lot of effort. Okay.
Yes, sir.
All right.
All right. Thank you.
You're welcome.
Fine. Fine.
All right. Who's next?
It's Ryan Johnson. So, okay, that's fine. We're entering a plea.
Sorry, I'm not finding it on the docket. Let me see if it's on the back.
We're actually pleading to an information. I know we added him late. CR 24-194. It was a writ, so it might have been under your writ number. It is now a CR number on an information.
It
Okay.
should be the last page of your docket.
Yes, I've got it now.
Okay.
All right, court calls cause number CR 24-194, State of Texas versus Ryan Parker Johnson. Mr. Johnson, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. You can lower your hand. Your name is Ryan Parker Johnson, is that correct?
Yes, sir.
Mr. Johnson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done?
Yes, sir.
Do you have any questions about anything before we go forward?
No, sir.
Mr. Schmidt, do you believe Mr. Johnson to be competent?
I do.
And you've explained to him his rights as they pertain to this case, including the advantages and disadvantages of a deferred adjudication plea?
I have.
All right, Mr. Johnson, you are charged by information with a third-degree felony offense of deadly conduct or discharge of a firearm. A third-degree felony offense carries a potential range of punishment of not less than 2 years in prison or more than 10 years in prison and a fine up to $10,000. I see that the plea agreement in your case is that upon your plea of guilty, the state's recommending that the court consider the evidence but not convict you, but to place you on 3 years of community supervision with a $1,000 fine plus court costs, reimbursement fees. And as part of the plea agreement, the state is rejecting two unfiled cases, an ag assault, deadly weapon, actually two offenses of aggravated assault with a deadly weapon. Is that your understanding of the plea agreement?
Yes, sir.
All right. And Mr. Johnson, I do have to inform you that you've not been indicted in this offense and charged with this crime by indictment, which is something that you are guaranteed by Texas Constitution and Texas statutory law, meaning that you cannot be prosecuted for a felony offense without being indicted unless you waive that indictment and you allow the state of Texas to prosecute you by filing an information. So that means that you have the right to have your case presented to the grand jury and for the grand jury to make a determination of whether or not they believe there's sufficient probable cause to bring this charge against you. Is it my understanding that you have discussed your rights with Mr. Schmidt regarding your right to an indictment and that you're waiving that right to indictment today and you're allowing the state to prosecute you with an information? Is that correct?
Yes, sir.
And is there anything about that process that you do not understand?
No, sir.
All right. And Mr. Johnson, has anybody threatened, forced, or pressured you to waive your right to a grand jury indictment?
No, sir.
All right. Then the court will find that Mr. Johnson has been admonished as to his right of indictment, that he has waived the same intentionally, knowingly, and voluntarily. All right, Mr. Johnson, then at this time, I'm going to ask you, how do you plead to the third-degree felony offense of deadly conduct, discharge of a firearm?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Board accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objections.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, Mr. Schmidt, I do not have a copy of that stipulation. Could you provide that to the court?
Yes, sir.
And back out just a little more. Yeah, for some reason it's not focusing. I can't. No, it's not coming through. I don't know, the camera's not focusing on it. Yeah, leave it right there. I'll just see what I can do. All right, thank you. All right, based on the evidence presented, the court finds that there is sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement today. The court defers a finding of guilt on the third-degree felony offense of deadly conduct, discharge of a firearm. The court places the defendant on 3 years community supervision, orders him to pay a $1,000 fine, $290 court cost, $515 in reimbursement fees. Further, the court finds that the state, as part of the agreement, is agreeing to reject 2 unfiled aggravated assault with deadly weapons as outlined in the court's judgment. All right, Mr. Johnson, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Step over to be fingerprinted, and then the probation officers will give you more information. Mr. Schmidt, if you'll do me a favor and look through your Michael Morton document there and tell me if your document has the disclosure of any evidence. Mine does not. My Michael Morton is blank.
Yes, sir. My Michael Morton is fully populated.
It is populated. Okay.
Yes, sir.
All right. If you're pleased with that, then I'm pleased with that.
I am, sir.
All right. All right. Who's next? Who is this?
It's James Weatherford.
James Carroll Weatherford, cause number CR 23-194, motion to revoke. Go ahead, Mr. Schmidt.
And Judge, I believe that was recently reappointed to represent Mr. Weatherford on the motion to revoke. I have not had an opportunity to meet with him on that motion as of yet. So we'd ask for a reset on this.
Any objection from the state?
No objection, Your Honor.
All right. I'm going to put Mr. Weatherford on the evidentiary docket for September 26th. Do you have any conflicts that day, Mr. Schmidt?
Potentially, Judge, if you give me 1 second.
Mhm.
No, we can make that work. That's fine, Judge.
Okay. All right. Mr. Weatherford is set September 26th at 1:30. All right. Who's next?
This is Mr. It's a capital, but it's Walfield.
Cavill. All right. This is cause number CR 22-220, State of Texas versus Nathan Allen Cavill on motion to revoke. Go ahead, Mr. Smith.
Judge, I would make the same announcement on Mr. Capital and ask for that September 26th. September 26th, Doug.
Any objection?
Yes, sir.
No objection, thank you.
All right. Court sets Mr. Cavill for contested hearing on September 26th.
Let me with you later. All right.
Want to go ahead and tell?
Yeah.
So, Mr. Krill, you need to come speak with Judge.
All right. This is cause number CR 23-158, State of Texas versus Brandon Ashley Krill. Mr. Schmidt, are you representing Mr. Krill?
Judge, I don't know yet. I know I've talked to Mr. Abraham. Mr. Krill was a prior appointment of mine, and I had prior dealings with him. At this point in time, I'm not certain that he has filled out the appropriate paperwork. I know he's been found indigent in the past, so if the court appoints an attorney, it's more than likely going to be me. So I'm here. It's up to the court. I mean, obviously, you might want to ask Mr. Creel.
Well, we have asked Mr. Krill several times to fill out the paperwork, and Mr. Krill has copped the attitude that he's not filling out anything and that it'll happen and he's not going to mess with it. And so I was going to give Mr. Krill the opportunity to either he thinks it's funny. He doesn't. Okay, I'll tell you what, Mr. Krill, I don't think it's very funny. So I tell you what, I'm going to reset your case for 30 days. So once you go back there, have a seat. And in the next 30 days, why don't you decide whether or not you want to fill out the paperwork? If you don't, that's fine. I'll see you in 30 days. No paperwork, I'll reset you for another 30 days. And if you want to sit out the entirety of your second-degree felony sentence, which could be 20 years, it's fine by me. Go have a seat. We'll see how funny you think it is when you can't get justice because you won't fill out the paperwork and the process can't work for you. Ms. Tabraham,
Yes, Your Honor.
Fincher.
is there any issue with Mr. Krill and his psychological behavior?
Mr. Smith believes so.
Like,
Yes, sir.
he may be incompetent.
Yes, sir. And I know that we've had extensive issues with his mental health in past proceedings. I may have filed competency motions on him. He was supposed to be on a mental health caseload as well. So that behavior is a result, I believe, of a mental health issue.
We haven't heard any of that information from the jail, and usually we do. Usually they're on top of their game if they think someone is incompetent or suffering from a mental health disease. So we haven't heard that from
I'm not surprised, Judge. Normally, Mr. Creel doesn't say boo to a goose unless he's pressured. So I wouldn't be surprised at all that he's compliant. But when I've had dealings with him in the past, he's had these similar issues.
All right. So what I'll do is I'll research the case. I'll go through all that and I'll collect the information from the jail. And if if there's a question about whether or not he is competent, then I'll appoint you and we'll go ahead and go through the competency procedure.
Yes, sir.
Thanks, sir.
Your Honor, Mr. Hyde is ready.
Okay. All right, Mr. Woods, if you'll come forward, this is cause number CR 24-10, State of Texas versus Jasmine Marquette Woods. Are we doing a plea today, Mr. Hyde?
Yes, Your Honor.
Let me see if I have paperwork over here. I think that I do. All right, Mr. Woods, sir, if you'll raise your right hand, I'm going to place you under oath. Do your other hand for me.
Oh, sorry.
It's all right. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Sir.
All right. Thank you, sir. You can lower your hand. I need you to speak up loudly and clearly so I can hear you and so that my court reporter can take down what you have to say. Okay?
Sir.
All right. Your name is Jasmine Marquette Woods. Is that correct?
Yes, sir.
And Mr. Woods, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
In this case, you're represented by your attorney, Mr. Scotty Allen. Is that correct?
Yes, sir.
And Mr. Heath Hyde has been attending court and acting as co-counsel for Mr. Allen. Is that correct?
Yes, sir.
That's correct, Your Honor.
And are you pleased with the legal representation that you've received from Mr. Allen and Mr. Hyde?
Yes, sir.
And do you have any questions about any of the paperwork that you've read and signed? That's your plea agreement.
No, sir.
Do you have any questions about anything before we go forward?
Yes, sir.
What's your question?
With the sentence I have, will it be ran concurrent with the parole that I'm on?
I don't see anything. It says in the judgment, it says the sentence shall run concurrently, but it's going to be up to parole on how they run your sentence. But this sentence does not say that it's going to run consecutive to any other sentence that you're running.
Yes, sir.
And that's a good question. Do you have any other questions?
No, sir.
Okay. And Mr. Hyde, do you believe that Mr. Woods is competent and that he understands the plea agreement and what he has entered into in this agreement?
He does, Your Honor. He is competent.
Okay. And can you just on the record, can you elaborate a little bit more about your representation as co-counsel with Mr. Allen so that we have a clear record on that?
Yeah, I've known Mr. Allen for nearly 30 years. Mr. Allen knows that I have an office in East Texas, and he approached me after getting involved in this case that he might would need my help. Mr. Allen is sick, and there is hard. It's reached a point where he can't travel, and at that point, I substituted in and followed up what Mr. Allen had reviewed. Followed up with Mr. Woods with my own personal opinion on it, and agreed with the arrangement Mr. Allen had worked out, and what he and Ms. Curry had reached an agreement on, and I concurred with that, and I explained that to Mr. Woods, and we've gone through all the different potential options that could happen. But I'm belief is I agree with Mr. Woods and Mr. Allen that this is the best deal.
All right. All right, Mr. Woods, you are charged by indictment with a felony offense of manufacture or delivery of a controlled substance in penalty group 1 greater than 400 grams. I believe, correct me if I'm wrong, Mr. Hartwell, I think this one is a modified range of punishment. You as well, Mr. Hyde. Is it what is the minimum range of punishment? Because this is a minimum 10 or 15?
I believe minimum 15, but I'm not 100% sure on that without looking it up, Your Honor.
Yeah, I believe that's correct.
Yeah, I believe that to be the case. I don't have my statute book with me, but Mr. Woods, the minimum range of punishment for this offense is 10 years confinement in the Texas Department of Criminal Justice Institutional Division, and not to exceed a period of 99 years or life confinement in the Texas Department of Criminal Justice, and a potential fine not to exceed $10,000. I see that the plea agreement in this case is that upon your plea of guilty, the state's recommending that your punishment be assessed at 18 years confinement in prison with a $4,000 fine being assessed in addition to court costs and reimbursement fees. And as part of the agreement, the state is dismissing an unfiled money laundering charge of value between $2,500 to $30,000. You would receive the time that you've already spent in jail towards this sentence, which is a total of 2 days. Is that your understanding of the plea agreement and what you're asking the court to approve, Mr. Woods?
Yes, sir.
All right, Mr. Woods, then how do you plead to manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 400 grams?
I plead guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt at this time. Mr. Hyde, is there any objection to the stipulation of evidence in this charge?
No objection, Your Honor.
All right, the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Is there anything further from state?
Nothing further, Your Honor. Thank you.
Is there anything further from the defense?
No, Your Honor.
Mr. Hartwell, I think I would like to have the judgment of conviction to reflect both Scotty Allen's name and Mr. Hyde's name as attorney for the defendant. If you could have Ms. Abney just change that first page, I'd appreciate
Yes,
that.
will do.
All right, and let me see if I have the stipulation of evidence. I do. All right, I'm gonna review the stipulation briefly. All right, the court, having reviewed the stipulation of evidence, finds that there is sufficient evidence to convict the defendant. The court will follow the plea agreement today. The court convicts Jasmine Marquette Woods of manufactured delivery of a controlled substance in penalty group 1 greater than or equal to 400 grams. The court hereby assesses punishment pursuant to the plea agreement at 18 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will assess a $4,000 fine. The court dismisses unfiled money laundering charge DA 2023-712. And the court assesses court costs at $290, reimbursement fees at $35, orders that this sentence run concurrently with any and all other sentences currently being served by Mr. Woods. And the court will award him 2 days credit towards his sentence for the time that he's already spent in jail on this cause. All right, Mr. Woods, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Thank you, Mr. Hyde.
Thank you, Judge.
Appreciate you helping Mr. Allen out and Mr. Woods in this time of need for him. So
Yeah, it worked out.
thank you, sir.
Are you involved in volleyball?
Yes, I am.
Okay.
And
There's a-
10U soccer and 10U soccer. That's new too.
There's a possibility I may see you tonight then.
Oh, excellent. Silver Springs in town.
Yes.
Excellent. Well, I look forward to it.
Okay. Yeah. That's something you can. And then I can come visit you.
Okay, down another county, I want you to see it, I should work.
Just a moment, Your Honor.
Okay.
So, on previous side. So, I'm gonna get time for that. Great. All right. Great, Rob.
Your Honor.
Your Honor. He's waiting in the wings.
Just woke up. Just trying to get my nap in and y'all have interrupted me. What do you want?
Sorry, I figured we just wrap this business up today and.
Let's do it.
Yeah.
Let's do it.
We have, Nicholas Fincher or Jordan Manning. One of the two. How about Fincher first, Judge?
Nicholas Christopher Fincher, CR 20-118, motion to revoke. Go ahead, Mr. Schmidt.
Judge, we're gonna keep working on sorting out Mr. Fincher's business. I asked that he be sent on that contested docket for the 26th.
All right, court sets Mr. Fincher for the contested hearing docket September 26th at 1:30.
Thank you, Your Honor.
You're welcome, sir.
Jordan Manning,
Mr. Manning, if you'll come forward. All right, I believe that this is an unindicted case, Mr. Schmidt?
yes, I believe it is. I didn't see Mr. Manning on my docket, but apparently he's here for pretrial release compliance or something like that. It's, as far as I know, it remains unindicted.
That's correct, Your Honor. It has not yet been presented to grand jury.
All right, give me just 1 second. Let me pull up his case. I've only got one of his pages of his conditions of pretrial release. Let me make sure that I'm the magistrate that signed those and I have jurisdiction to do the hearing.
Yeah. Judge has.
Miss Tabraham,
Yes, Your Honor.
do you know, so I only have one page of his conditions of pretrial release. I don't have the second page. Do you know if I was the magistrate that placed these conditions on him?
Ms. Burns said that you signed the conditions on what?
I have a set of older conditions for the offense of assault, public servant, resisting arrest, and criminal mischief. Is that the page you have?
Yes.
You did sign those, and then there was a new set that was done on August the 14th that you signed that Mr. Manning has not signed.
But that's a new charge.
Okay, thank you. Thank you. And that's what Mr. Manning's currently being held on,
No. Yes,
on the new
Yeah.
charge.
yes, assault and possession.
Okay, excellent. Okay, all right, so this is a pretrial release, conditions hearing. Court, having scheduled this, due to Mr. Manning being arrested on the new charge. Does the defense want to be, heard on why, the court should or should not consider, revoking his pretrial supervision?
Well, Judge, I didn't have notice, but I would note for the court that the instant offense that he is on pretrial release conditions for are a year old and remain unindicted. So I would have to go back to his file from a year ago when I was initially appointed to review that to determine what the issue is. I mean, theoretically, depending on the timeline, he would have been entitled to a motion to dismiss under delay. But I'm uncertain what those deadlines would look at without further review. I do understand that he's been charged with 2 new offenses. Obviously, those are unindicted as well. So as of right now, I would ask the court defer a ruling, give me an opportunity to look at that timing and perhaps file an additional motion on Mr. Manning's behalf pertaining to the oldest offense.
State, do you want to be heard?
Your Honor, I have no objection to deferring a ruling on today's matter so that Mr. Schmidt can prepare a motion or do some legal research. Obviously, if Mr. Manning gets out, he's going to have new conditions of pretrial release. We don't yet have any kind of a PC affidavit yet. I expect we'll be getting something shortly, but I don't have any facts of the new case.
Mr. Schmidt, are you coming back to court on the 24th?
Of what month, Judge?
September.
Yeah, I believe I am. I'll be back on Thursday as well.
All right, we'll reset this to September 24th. The hearing on the conditions of pretrial release.
Yeah.
Thank you, Your Honor.
Oh, wait.
You're welcome, sir.
Manning, thank you for your condition.
All right, Mr. Schmidt, just give me just one moment. Don't go anywhere. Stay right there.
like these pretrial conditions. Let me tell you, because I'm not trying to, but I believe.
Or I'm on YouTube.
All right, Mr. Schmidt. All right, this is cause number CR 24-132, State of Texas versus Robert Way Driscoll. And we're set for plea today. Is that correct? Let's see, hang on. I've got no audio. Hang on.
Your Honor, I believe they're on mute.
That's a demerit, Mr. Abraham.
I know.
All right. So are we going forward with the plea today, Mr. Schmidt?
We are, Judge. We're ready to proceed.
All right. Mr. Driscoll, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Is your name Robert Way Driscoll?
Yes, sir.
And Mr. Driscoll, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Do you understand all of the paperwork and parts of your plea agreement that you signed today?
Yes, sir.
Is there any questions about any of that before you proceed further?
No, sir.
Mr. Schmidt, do you believe Mr. Driscoll to be competent today? And if so, have you explained to him his rights as they pertain to this case?
Judge, I do believe he is competent, and I have explained to him his rights in detail, as well as the pros and cons of deferred adjudication. Prior to proceeding to accept his plea, I would ask that I be allowed to question Mr. Driscoll briefly before we proceed.
Okay, let me go over some of his statutory warnings, then I'll allow you to do that.
Yes, sir.
All right, Mr. Driscoll, this is cause number CR 24-132, in which you are charged by indictment with a second-degree felony offense of sexual assault of a child. That charge does carry a range of punishment of not less than 2 years in prison or more than 20 years in prison, and also carries a fine not to exceed $10,000. A plea of guilty on this charge would also require a sex offender registration under Chapter 62. Mr. Driscoll, do you understand that full range of punishment?
Yes, sir.
And I see that the plea agreement in this case is that you would plead guilty. The state's recommending that the court consider the evidence, not convict you, but place you on deferred community supervision for a period of 5 years. They're also recommending a $2,000 fine. In addition, you would have reimbursement costs of $570. All right, Mr. Schmidt, at this time, I'm gonna go ahead and allow you to question Mr. Driscoll.
Thank you, sir. Now, Mr. Driscoll, we have spoken and met about your case, and we've had communications about the legal ramifications of your plea, have we not? Yes, sir. And I informed you that you have a right to a jury trial and that these allegations are nearly 20 years old, and you understand that. Yes, sir. Now, I encouraged you or urged you to delay entering a plea and to actually take this case to trial, but with the caveat of the pros and cons of that choice. Is that correct? Yes, sir. And I also explained to you in detail the collateral consequences of entering a plea of guilty. And are you telling the court that you understand all of those collateral consequences of entering a plea today? Yes, sir. And based on all those discussions and my warnings, is it your desire to proceed with this plea? Yes, sir. I'll pass the questions.
Any questions from the state?
No, Your Honor, thank you.
All right, anything further, Mr. Schmidt?
No, sir.
All right, so Mr. Schmidt, you said that you do believe Mr. Driscoll to be competent, and you have explained to him the advantages and disadvantages of a deferred adjudication plea.
I have, sir. Yes.
All right, Mr. Driscoll, then at this time, I'm going to ask you, how do you plead to the second-degree felony offense of sexual assault of a child?
Guilty.
Now, are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the admission of the stipulation of evidence?
No objection.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that the state is in compliance. Victim impact statement was sent out about 2.5 months ago, was not returned. And as a follow-up, Ms. Cheney has made attempts to reach the victim by phone, has left voicemails, but has not received a call back.
Okay, so the DA's office has had no contact from the victim.
Correct, Your Honor.
Okay. Mr. Schmidt, anything further?
Yes, Judge, I just would note for the court that supplemental admonishments have been executed by Mr. Driscoll, and I have received a copy of Chapter 62.
All right, thank you, Mr. Schmidt.
Yes.
And Mr. Hartwell, I do need to ask and seek a point of clarification. The proposed judgment says the age of the victim at the time of the offense was 15 years old. However, there's also a reference in the probation referral form that says that the age of the victim at the time was 11 years old. Can you clarify that for me?
Yes, Your Honor. Due to the length of time that the victim was staying with Mr. Driscoll. We're ultimately not sure exactly how old he was, which is why we're proceeding on sexual assault rather than aggravated sexual assault. Initially, our paperwork had that 11 years of age. However, because we're not exactly sure what year this occurred in, the judgment was changed to 15 years old, because that would correct it from making it an aggravated, due to the length of time, as Mr. Schmidt has referenced earlier. These events occurred nearly 20 years ago, was reported recently, I believe as end of last year. So being that there was a 20-year delay in the events and the outcry, and why we're here today, some of our dates are a little bit difficult to be sure of, other than we know that the victim was under 17 at the time.
Thank you, Mr. Hartwell. I appreciate that clarification. All right, court will consider the evidence. Mr. Schmidt, I do not have a copy of the stipulation. Can you provide that to the court?
Yes, sir. One moment, please.
Perfect, right there. All right, thank you, Mr. Schmidt.
Yes, sir.
All right, the court, having considered the evidence, the court finds that there is sufficient evidence to convict Mr. Driscoll of this offense. The court will follow the recommendation of the state of Texas through the DA's office, and the court hereby defers a finding of guilt of Robert Way Driscoll for the second-degree felony offense of sexual assault of a child, a second-degree felony. The court places Mr. Driscoll on 5 years community supervision, orders him to pay a $2,000 fine, $290 court cost, $570 in reimbursement fees. Further, the court finds that Mr. Driscoll, having been prosecuted under Chapter 62 of the Texas Code of Criminal Procedure, finds that Chapter 62 does apply, and that Mr. Driscoll is ordered to register as a sex offender for the remainder of his life. The court finds also that the victim's age at the time of the offense was 15 years old. Court notes that Mr. Driscoll has been provided a copy of Chapter 62 in compliance with the law. All right, Mr. Driscoll, you hereby remanded to the custody of the probation department so they can carry out the conditions in terms of the judgment. I'm going to have you step over to be fingerprinted with the bailiff, and then the probation officers will give you more information. Mr. Abraham,
Yes, Your Honor.
let's go ahead and appoint Mr. Schmidt to Mr. Krill. Okay, and then we don't have to do it right now. I'm just making a note. And let's go ahead and we'll reset Mr. Krill for September 26th.
Okay.
And that'll give Mr. Schmidt time to review what he needs to, but we'll go ahead and appoint him and get him set.
Thank you.
Mhm.
And we'll be over. He's gonna appoint you on Mr. Krill,
Mr. Krill, okay.
and he's gonna send the 926.
Okay.
Okay, we'll see you in a minute.
All right, thank you.
Post.